Welcome back to the High Court Report. How was your Thanksgiving? Did you reconnect with family and friends? Eat a lot of food and sweets? Did anyone mention a Supreme Court case? If so, how'd it go? Message me via LinkedIn, YouTube, or email, and I'll read your response. I enjoyed spending time with my family. Did I eat way too much food? You bet. But I didn't want Thanksgiving to slow me because I aim to finish this year strong. All week, I upped my exercise and water intake. Exercise to stimulate the metabolism and water to feel full. I even managed a post-dinner Thanksgiving walk. Speaking of finishing strong, New Year's is right around the corner. Did you make resolutions? Now's the time to start finalizing them. This month, I challenge you to envision success for 2026. Think positively and about achieving your goals. I want everyone to dream big and be the best version of yourself. All right, I've hyped the mailbag episode now for 2 weeks. It's finally here. Here's today's game plan. I'll answer questions and then run through the December Supreme Court docket. Remember, you can find us on Apple Podcasts, Spotify, YouTube, and wherever you get your podcasts. Just search the High Court Report. And remember, if you liked the episode, please follow, rate, subscribe, and share. Let's begin. First question, and I get this a lot. Who are the best lawyers that argue cases in front of the Supreme Court? Are there any that really stand out to you? Here's a few names that stand out to me. Michael Dreeben. He's a longtime Justice Department lawyer who argued over 100 cases before the Supreme Court. He's a stalwart. I've listened to the Trump immunity oral arguments probably 7 to 10 times. He delivered an unparalleled performance. The way he answered each justice's question in hypothetical form, and then by tying the hypotheticals to the case at hand, embedding institutional knowledge within his answers, and interweaving decades of Supreme Court precedent into each answer. Here's an exchange between Michael Dreeben and Justice Alito in the Jack Smith Special Counsel Trump immunity case.
Do you really, the presidents have to make a lot of tough decisions about enforcing the law, and they have to make decisions about questions that are unsettled, and they have to make decisions based on the information that's available. Do you really, did I understand you to say, well, if he makes a mistake, he makes a mistake. He's subject to the criminal laws just like anybody else? You don't think he's in a peculiarly precarious position?
He's in a special position for a number of reasons. One is that he has access to legal advice about everything that he does. He's under a constitutional obligation he's supposed to be faithful to the laws of the United States and the Constitution of the United States. And making a mistake is not what lands you in a criminal prosecution. There's been some talk about the statutes that are issued in this case. I think they are fairly described as malum in se statutes, engaging in conspiracies to defraud the United States with respect to one of the most important functions, namely the certification of the next president.
Another person that stands out to me, Lisa Blatt. She's a bit unorthodox in her delivery. She's also extremely candid, but she's crafty and deft, unique. She wins a lot at the Supreme Court. Now, in one case last term, she was maybe a little too candid. She got in hot water for calling an opposing lawyer a liar. This noun took the justices by surprise. After all, lawyers customarily call opposing lawyers their friends at the Supreme Court. Here's the exchange. This clip comes from AJT v. Ossio, a case heard last term.
The disconnect is there's this, it's a lie to say that we never defended Monahan by the text. It's on page 26 of
No, I'm not.
Opposition.
I don't think the argument is that you never defended it by the text.
Well, what is a lie and what is inaccurate?
Well,
if I could just get this out. If I could just get this out, please. What is a lie and inaccurate is that we ever said in any context that this court should take the same language and define it differently depending on context. That is not true. There is no statement. They adding words to our mouth. We never said you should have a double regime. What the school district has said, which is what Monahan said,
you believe that Mr. Martinez and the Solicitor General are lying?
Is that your an oral argument? Yes, absolutely. It is not true that we
should be more careful with your words.
Okay, well, they should be more careful in mischaracterizing a position by an experienced advocate of the Supreme Court, with all due respect. Fine, but what I'm objecting to...
Fine. Then would you withdraw your accusation?
I'll withdraw it.
Thank you. That's
okay.
it.
That's fine.
Lisa Black lost this case, but not for this reason. In fact, the case was unanimous against her, which shows that even the best advocates sometimes lose big. But she bounced back. Here's a clip of her this year in Coney Island versus Burton. This exchange pretty much ended the case in her favor.
Mr. Ginsburg says that almost all the courts of appeals have decided this question against you, and the leading commentators take the opposite position. How do you account for that?
So I think that's correct. I think these courts were writing, either now or at the time in a way that they were comfortable not following the literal text. Some of them acknowledge that they're not following the literal text, and this is just not consistent with the court's modern approach. I will say that most of these courts, at least 5 of them in the dissent, trace back to this D.C. Circuit decision from 1962, Austin versus Smith, that just didn't even mention Rule 60C1. But since, the coming of Justice Scalia in 1986, the court has taken just a different approach to statutory interpretation. And we cite an example of, I think it's U.S. versus Brogan, where all the courts of appeals had ruled 1001 gives you a right to lie, and this court just said, we're going to overrule that. And I think just last term you ruled against a case I argued when all the courts had gone our way.
I'll also mention a few others. Paul Clement. He's great at answering questions directly, but then quickly pivoting. He's also funny, dynamic, and charismatic. Here's a funny exchange between Paul Clement and Justice Alito in the case Netgear versus Paxton. This was the 2023 case where the Supreme Court considered the constitutionality of a Texas law that regulated social media moderation practices.
Well, we exercise editorial discretion. That doesn't shield you from liability.
Not at common law, and that's why Congress had to come in with 230. But what Congress did is it looked at the common law and it said, oh, this is problematic. Because the only way you can avoid liability at common law is if you act as a conduit and let everything out. And once you start keeping out a little bit of porn, then you're responsible for the porn that slips through. And that's not practical on the Internet, and that's why we have 230.
Right, I don't want to belabor the point.
I laugh every time I hear this segment, thinking about Justice Alito's reaction to when he hears that phrasing. Let's see. Jonathan Mitchell, Hashim M. Mupan. Those are 2 other advocates I enjoy listening to. I also thought that Janae Nelson did a really good job this term in the Louisiana and Robinson v. Calais case. All right. Next question. What case gets you the most fired up this term? Excellent question. I'm a nerd and I enjoy the mundane civil procedure cases. Since I litigate, I interact with the rules of civil procedure almost every day. Of the civil procedure cases so far, I really liked Burke versus Choi. I'm also intrigued by the Trump tariff cases. I know, that's low-hanging fruit, but the subcurrents of that case hits hard on areas of interest to me, plus it will directly impact my wallet. I'll also highlight one more case. National Republican Senatorial Committee versus Federal Election Commission. If you don't know yet about this case, check out our preview for this case. We released it last week. Campaign finance cases touch upon everyone's everyday life, so I'm particularly interested to see how that case shakes out. I remember when the landmark campaign finance case Citizens United versus FEC came out. I was a senior in college, and I read the case in law school. Justice Stevens wrote a 90-page, yes, 90-page dissent. NRSC holds less significance than Citizens United, but I think it will spark a similarly passionate dissent. Next question. What do you listen for in oral arguments? I listen for a few things. 1. Justice Thomas's questions. Justice Thomas always opens each side's argument with the most cutting question possible. His questions form the foundation of all other questions from the other justices. Multiple times in each argument, a justice will say, following up on Justice Thomas's question, or let's get back to Justice Thomas's original question. That signals to me that his questions impacted the other justices' thinking one way or the other. 2. How many questions each side gets and how tough those questions are. That often reveals which way the justices lean. 3. The swing voters' questions. Usually that means Chief Justice Roberts and Justice Barrett. And 4. What hypotheticals the justices use. The justices love using hypotheticals to test the limits of each side's position. They want to consider not just the facts of the present case, but the facts of a future case with a completely different set of circumstances, but that involves similar legal questions. They want to understand the full scope and implications of their ruling, and they use hypotheticals as a tool to do so. On the advocate side, I listen for the opening statements. The opening statements roadmap each side's position. If you're looking for an exceptional opening statement, listen to J. Benjamin Aguinaga's opening statement in Landor versus Louisiana Department of Corrections. He's the Solicitor General of Louisiana. I really enjoyed the end of his opening statement in particular, where he played to the justices' preference to not create judicially preferred outcomes when Congress wrote an unclear law. He said, basically, while my preferred outcome may seem unjust, it's Congress's role to write a better statute, not your role to judicially rewrite the statute. Here's a clip of that opening statement.
Now, to be sure, I have a lot of friends on the other side of this case who have valid concerns about Congress's silence over the past 25 years when 10 federal courts of appeals have said that there's no individual capacity claim for damages under RLUIPA. But the solution is not to distort this court's existing precedents to try to change that status quo. It is instead to tell Congress to act exactly like it did in 1993 after Smith and in 2000 after City of Bernie, which is to pass new legislation, supersede Sosamon, and amend RLUIPA to allow for damages against the states. And then the states can decide, each state for itself, whether it accepts that express condition. The answer is across the street, not here. I welcome the court's questions.
I thought that landed really well. I also listen to how well the advocates answer and pivot to their strongest points. How well they parry punches. I'll also listen for when advocates quibble with the hypotheticals or give evasive answers. The justices dislike when advocates quibble or sound evasive. That can sometimes evoke a spirited back and forth with the justices. Next question. I saw that a judge tossed the indictments of James Comey and Tish James. Why? I'm sure most of you heard the news. Earlier this week, a federal judge in Virginia dismissed criminal charges against former FBI Director James Comey and against the New York Attorney General Letitia James. The judge ruled that the Trump administration illegally appointed the prosecutor who brought the case, Lindsay Halligan. Here's the issue. Federal law limits the executive branch's power to appoint interim U.S. attorneys to 120 days. After that, under this statute, only federal judges can make interim appointments. According to the judge, since the prior U.S. attorney's original 120-day appointment expired, the executive branch had no authority to appoint Halligan in September. I absolutely see the Supreme Court taking this case this term. As we know, the Supreme Court plans to hear 2 cases dealing with the president's power to appoint people to the executive branch. This case fits the mold in terms of public interest, overlapping issues, and similar questions percolating across different states in federal courts about Trump's bypassing of this statute to appoint U.S. attorneys. Next question, and this message comes from my friend Peter. He asks, I saw online that the UK may eliminate jury trials for certain crimes. Could this happen in the United States? Thanks for the question, Peter. The short answer is no, not unless we first amend the Constitution. In case you didn't hear, on November 25th, the BBC reported that the United Kingdom's Justice Secretary David Lammy wants to eliminate jury trials for most serious crimes, guaranteeing jury trials only for murder, rape, manslaughter, and special public interest cases. The reason for this is because the Crown courts face record backlogs with over 78,000 cases, meaning that suspects charged today may not get trials until 2029 or 2030. The proposal would create a new Crown Court bench division where judges alone decide cases involving defendants facing up to 5 years in prison. Critics argue this attacks a foundational principle of the British justice system and won't actually solve the problem of systematic underfunding, which they claim is the reason for the backlog. If all goes well for David Lammy, he hopes to propose this legislation in the new year. Now, back to Peter's question. Can this happen? Can Congress or the president do this in the United States? Fortunately not. Fortunately not. Congress and the president cannot do this without first amending or repealing the Sixth Amendment of the Constitution. The Sixth Amendment guarantees the right to a speedy and public trial by an impartial jury. I think the Supreme Court would easily strike this down. The current Supreme Court recently required the SEC to win a jury trial before imposing civil penalties for securities fraud. Now, these are civil cases, not criminal cases where the prospect isn't just paying a fine, but imprisonment. If a person facing SEC penalties gets a jury trial, so do people facing felonies. Next question. Do you root for one side or the other? Nope. Despite what an early Apple Podcast reader said, I don't favor one side or the other. Actually, this early feedback helped me double down on reviewing episode content to ensure impartiality. I find that unbiased coverage not only helps me deliver a better podcast, but allows me to listen freely. Next question. What's the most recent movie you saw? I'll give you 2. First, Gangs of New York. I grew up loving historical crime dramas, but I never saw this movie. It came out in 2002 when I was in, 9th grade? The movie was outstanding. It had a stellar director and an incredible cast. Martin Scorsese helmed the movie as director. It also featured Leonardo DiCaprio, Cameron Diaz, John C. Reilly, and Brandon Gleeson. And of course, Daniel Day-Lewis, who stole the show. This was only the second movie I've seen of his, the first being There Will Be Blood. I thought Daniel Day-Lewis absolutely crushed it. He played an exceptional character, savvy but ruthless as a villain from the Civil War era. His walk, his voice, his demeanor, he really sold the character. This movie stood the test of time. If you're looking for a movie to watch over the holidays, check out Gangs of New York. Second, a 1957 legal drama called A Witness for the Prosecution. This black and white film noir was adapted from a 1953 play by Agatha Christie. This movie hit all the key points for a legal drama. A surly old barrister, suspense, plot twists, a toxic work environment, and courtroom drama. Plus, it's set in the UK, so you can see the judge and other characters wearing Thomas Jefferson-style wigs. Highly recommend. Okay, next question. Salty or sweet? Trick question, both. Next, coffee or tea? Tea all day. Next, minimalist or maximalist? Can't you tell from my show notes? Maximalist. When I write legal briefs, I'm definitely at the page limits. Next, and final question, what are your thoughts on Kim Kardashian saying she uses ChatGPT for legal answers? Yikes. Asking ChatGPT or other AI platforms for ultimate answers will almost certainly lead you down the wrong path. Not to toot my own horn, but I call myself a sophisticated AI user. I became an early adapter to AI, including in the legal space. I never ask AI for the ultimate answer. Instead, I use it to brainstorm, organize details, to streamline my thinking, and to help me reach my own conclusions. I'll use it to enhance, not to replace my thinking, and that's the main point. Legal prompting requires a lot more than simply asking a dense legal question. You need to do your own research, formulate your own impressions, give considerable context, and think critically. Smother AI with multiple layers of human involvement. Multiple checks and balances to safeguard against misuse, inaccuracy, and confirmation bias. Now, in a lot of ways, I can't fault her. Imagine if IKEA didn't give instructions when they sent you the materials to build a closet. That's what OpenAI and some of these AI companies do, or don't do. These companies make grand claims about their products' prowess and simplicity, but they don't give guidance on proper use. It's purely on you, the user, to figure all of it out. The fact that Kim Kardashian, a billionaire, didn't use AI well, to me speaks more about OpenAI's failure to inform users about how to properly use their products. Everyone, please take the time to become competent in AI before using it to answer serious questions. I could talk about AI for days. Maybe another episode we can talk more. All right, that's it for the mailbag. I hope you enjoyed it. What was the last movie you saw? Do you prefer coffee or tea? Are you a minimalist or a maximalist? What's an AI tip you'd like to share? Send your thoughts via email, LinkedIn, or YouTube, and I'll respond. Now, let's turn to the upcoming December cases.
December delivers 7 constitutional thunderbolts.
December 2025 presents 7 cases that fundamentally challenge how power operates in America, from presidential authority over federal agencies to whether your internet provider polices copyright violations.
In just 10 days, the court will hear cases that determine whether the president controls the entire federal bureaucracy, whether your internet provider becomes your copyright cop, and whether getting convicted once immunizes bad laws forever.
Plus campaign finance cases that could unleash unlimited party spending, death penalty cases where IQ points determine life or death, and jurisdictional battles that decide whether federal courts actually protect federal rights. Each case alone would headline a Supreme Court term. Together, they represent the most concentrated dose of constitutional change we've seen in decades. Here's what you need to know.
December kicks off with Cox Communications versus Sony Music Entertainment, billion-dollar broadband battle, when ISPs face copyright catastrophe, with oral arguments on December 1st. This case exposes a massive crack in how we think about internet liability. Cox faced 5.8 million copyright notices in 2 years, but terminated maybe 50 customers total. Meanwhile, their internal emails mock federal copyright law.
Sony argues that's deliberate facilitation worthy of billion-dollar punishment. Cox calls it neutral internet service that shouldn't face copyright enforcement obligations. The Fourth Circuit essentially created a cut them off or pay billions rule.
The government surprisingly backs Cox, arguing that providing infrastructure can't create accomplice liability just because some users misbehave. It's like holding phone companies liable when criminals use telephones.
The broader question cuts deeper, though. Should private companies become copyright enforcement arms? Because if Cox loses, every ISP becomes a copyright tribunal, deciding which customers deserve internet access based on unproven accusations.
This billion-dollar broadband battle could reshape internet access costs, rural broadband expansion, and whether innovation thrives or gets strangled by copyright catastrophe.
December 2nd brings First Choice Women's Resource Centers versus Platkin, jurisdictional jam when state subpoenas silence speech. New Jersey's Attorney General demands donor lists from pregnancy centers, claiming consumer protection concerns. But First Choice points to nationwide attacks on similar facilities and argues this jurisdictional jam threatens constitutional rights when state subpoenas silence speech.
The procedural trap gets really insidious, though. Federal courts say, wait for state enforcement. Then when enforcement starts, they say wait for contempt threats. Then probably wait until you're actually jailed.
Right, and that creates this constitutional catch-22 where you potentially forfeit federal forum rights forever through state court res judicata. It's like Congress created a bridge to federal court, but courts keep moving the entrance ramp. What transforms this from administrative procedure into constitutional crisis gets you to the scope. Tech companies, advocacy groups, gun manufacturers, anyone facing hostile state investigations could lose federal court protection in this jurisdictional jam.
The government's support for First Choice signals something important, too. The executive branch thinks federal courts should actually be accessible when state subpoenas silence speech. Novel concept, apparently.
December 3rd delivers Olivier versus City of Brandon, Sidewalk Sermons, and Section 1983, the Prospective Relief Puzzle. Gabriel Olivier preaches during his sidewalk sermons, gets convicted under a questionable ordinance, pays his fine, then tries to prevent future enforcement. The Fifth Circuit says his prior conviction permanently bars federal court review under Section 1, 8 judges dissent calling this absurd. Think about the perverse incentives this prospective relief puzzle creates. Governments could deliberately target one person for conviction during their sidewalk sermons, then claim immunity from constitutional challenges by anyone else. Past enforcement becomes future protection.
The Heck Doctrine never contemplated this scenario. It was designed to prevent prisoners from challenging their convictions indirectly through damages claims. Olivier seeks prospective relief without challenging his past conviction. The constitutional stakes multiply across practice areas too: police misconduct, unconstitutional arrests, discriminatory enforcement. If prior convictions immunize bad laws, then constitutional violations essentially get grandfather protection in the Section 1983 puzzle. The government backing Olivier suggests federal law enforcement understands this threatens constitutional enforcement generally, not just sidewalk sermons specifically.
December 8th brings Trump versus Slaughter, a presidential power play, Trump's total takedown of independent agencies. President Trump fired FTC Commissioner Slaughter via email for conflicting with his priorities. No cause, no process, just presidential preference. The question becomes whether Article 2 grants absolute hiring and firing power over everyone exercising federal authority.
This presidential power play strikes at agencies controlling $47 trillion in economic activity. The Federal Reserve, SEC, FRB. Trump's total takedown of independent agencies could make regulatory stability evaporate with each election.
Commissioner Slaughter argues that multi-member agencies protect individual liberty through deliberative processes and prevent arbitrary government action. The president counters that democratic accountability requires presidential control.
But here's the deeper constitutional tension. Does Article 2's executive power clause override Congress's ability to structure institutions for expertise, stability, and insulation from political pressure?
The practical consequences of this presidential power play boggle the mind. Interest rates fluctuating with elections, antitrust enforcement reversing every 4 years, consumer protection disappearing when industries capture agencies through presidential appointments.
December 9th showcases National Republican Senatorial Committee versus Federal Election Commission, money, messaging, and muzzling, the First Amendment fight over party coordination. The NRSC challenges coordination limits in this fight over money, messaging, and muzzling that restricts party spending with candidates while allowing unlimited independent expenditures by super PACs. The constitutional irony cuts deep in this First Amendment fight over party coordination. Political parties face speech restrictions tighter than groups with zero democratic accountability. This money, messaging, and muzzling allows parties to spend unlimited amounts alone but faces caps when coordinating with their own candidates.
What makes this explosive politically gets you to the unusual alignments in this First Amendment fight. The FEC switched sides completely after Trump took office. Democrats intervened to defend laws their own government refuses to support. The First Amendment tensions run deeper, though. Why should coordination, essentially political communication, trigger stricter scrutiny than independent advocacy? This money, messaging, and muzzling is like penalizing teamwork while rewarding isolation.
If parties win unlimited coordination rights, they could regain prominence after decades of declining influence relative to super PACs. That could fundamentally alter how campaigns operate and where political money flows in this fight over party coordination.
December 10th closes with 2 fascinating cases. First, Hamm versus Smith, IQ score showdown, when multiple tests determine life or death, and FS credit versus Saba, fund feud forcing fiduciary fairness through federal lawsuits.
This IQ score showdown asks whether courts evaluate multiple IQ scores collectively or whether any qualifying score triggers constitutional protection. Joseph Smith scored 75, 72, 78, and 74. Does that 72 save his life?
Alabama argues multiple scores provide better evidence than isolated measurements. Federal courts focus on measurement error around that single low score. The Supreme Court must choose between comprehensive analysis and individual score protection when these tests determine life or death.
This affects hundreds of current death row inmates and every future capital case. The constitutional stakes involve whether intellectual disability protection depends on statistical averaging or includes measurement uncertainty.
Then fund feud tackles implied private rights of action for investment disputes. Can activist investors sue funds directly in federal court when forcing fiduciary fairness through federal lawsuits? Or does the SEC maintain exclusive enforcement authority? This fund feud turns on whether Congress intended Section 47B's rescission at the instance of any party language to create individual rights or just describe judicial remedies when forcing fiduciary fairness. The decision affects millions of Americans investing in mutual funds and determines whether activist investors get new federal court tools or face SEC-only enforcement channels in this fund feud.
7 cases, 7 constitutional battles, 7 opportunities to reshape fundamental aspects of American governance and individual rights. What strikes me most powerfully about this December lineup gets you to how these cases interconnect across seemingly separate constitutional domains: executive power, free speech, civil rights, criminal justice, financial regulation. They all depend on deeper questions about governmental structure and individual protection. The timing creates extraordinary pressure too. These decisions drop during the 2026 midterm election cycle, affecting campaign finance rules, regulatory enforcement, and constitutional challenge procedures while voters participate in democracy.
The court's decisions will ripple through every level of American law: federal agencies, state governments, local enforcement, private litigation, even international competitiveness, as regulatory stability affects global investment.
Thanks for joining our December case preview. Follow the podcast for ongoing coverage of these cases. Connect with us on LinkedIn at the High Court Report for ongoing coverage of this transformational case. Talk to you soon.